Okay, welcome everyone to this CIPIL seminar. My name is Henning Gross-Ruß-Kahn. I'm one of the co-directors of the Center for Intellectual Property and Information Law at the University of Cambridge. I'm very, very happy and glad today to be hosting Professor Haochen Sun from Hong Kong University, where he is an associate professor of law. Haochen Sun will talk and present his book on technology and the public interest, just freshly off the press from CUP, looking at intersections of technology and the public interest. I think, at least from what I've seen so far about the book, it's making very sort of acute, important arguments about re-examining the nature and scope of the right to technology, how to protect it under human rights law, internationally, as a collective right under domestic civil law, and potentially even as a fundamental right under domestic constitutional law. So, very exciting topic we're going to be hearing about. And Haochen Sun is been working not only on this sort of topic of interfaces between technology and the public interest, and I guess in that context also intellectual property law. He's looked at various other aspects of intellectual property law, including, for example, co-editing books on the luxury economy and IP, the Cambridge Handbook on copyright limitation and exceptions in a comparative perspective. And he is also co-editing books which are about to appear fairly soon. So, for example, on limitations on trademark rights and data sovereignty and the digital Silk Road. So, again, really sort of showing broad scholarship. I'm really interested, Haochen, to hear on this particular topic, but perhaps also to host you in the future once these sort of other exciting works are out. But I think for today, let's focus on the technology and public interest interface. So I guess I'll just hand over to you, and the floor is yours. Thank you.
Thank you very much, Henning. Thank you for the lovely introduction, and thank you for hosting today's webinar. So I'm very excited to give the first talk on my book. As Henning just pointed out, this book was published by Cambridge University Press just last month. So I'm very glad to kick off my book talk series at Cambridge University that houses and operates my publisher, CUP. So let me share my slide, or maybe just let me show my book. This is my book. So let me share the slides. I'll be very quick. So as Henning pointed out, this book deals with the intersection between technology and the public interest. And I have been working on this topic for a number of years. And so before I delve into the details of the book, I would like to talk a bit about the background of the book and some information about why I wanted to write about this book. So first of all, I think the current pandemic has given me a lot of thoughts about the importance of technology in promoting the public interest. And so first of all, I think the pandemic has actually taught me a great deal about the way in which technological benefits have been unevenly distributed among members of the public. Access to the internet is one of the best examples. For example, in 2000, around 50 million students in the United States shifted to online education because of the COVID pandemic. And at the same time, you can see that around 10 million of these students had actually no reliable internet access in their homes. So that's about 20% of these students. And this number was quite staggering. And so online education is just a function of the internet. We also have relied on the internet to deal with boredom and even despair caused by the pandemic while we stayed at home, right? So we had to, for example, rely on social media outlets such as TikTok, YouTube to have entertainment, and we heavily rely on the internet to have access to the information about COVID. So much of such information has been made only on the internet. So if internet is not accessible to many people, it's actually a matter of life or death. And it's not only a problem that has existed in the United States. Access to the internet has actually become a global problem. For example, as of February 2020, 42 million people in the United States were unable to purchase broadband internet access. Bear in mind that the United States has the most advanced technological base in the world. And in 2019, research has found that nearly half of the world's population had no access to broadband internet. So this is a very important element about the current pandemic. And at the same time, I think COVID-19 vaccines also posed formidable challenges to the ways in which technology can promote public interest. So for example, as of September 2021, a mere 3% of people in low-income countries had been vaccinated with at least one dose. But in stark contrast, 60% of the population in high-income countries have been vaccinated by that time. And one of the reasons is that governments around the world have paid between 4 and 24 times more than they could be for COVID-19 vaccines. This is because some major pharmaceutical companies have charged a lot more. And at the same time, you can see that Pfizer and BioNTech sold their COVID-19 vaccines to African Union countries at the lowest reported price of 6.75 per dose. But this charge is nearly the same as Uganda's health expenditure per citizen in the whole year. So you can see that this kind of severely uneven distribution of COVID-19 vaccines poses a question about the purpose of technology. Are we applying technology in the public interest, benefiting humanity, or just benefiting just a limited number of the advantaged? And at the same time, I have also been thinking about the irresponsibility of many technological companies. So let me focus on social media companies first. I think for many social media companies, they have obtained powers that have far exceed the responsibilities that they have assumed. So there is a severe asymmetry of power and responsibility. And Facebook is a textbook example. So I think the audience is aware of the massive breach of personal data that Facebook has caused. This infamous Cambridge Analytica scandal has exemplified the ways in which Facebook has been causing such a catastrophe for many of its users. And at the same time, Facebook has been inadequately dealt with fake news that has been circulating on their platforms. This actually, as many of you know, profoundly affected the 2016 US presidential election. So that's no wonder why Facebook has actually been denounced by a judge as a tool for evil in its judicial ruling. And whistleblowers and journalists have actually provided hard evidence demonstrating that Facebook has prioritized profits over the well-being of its users and society. At the same time, if we take a look at tech companies as patent holders, they actually have been abusing their rights too. So this kind of irresponsibility problem is actually very serious when it comes to their role as patent holders. So let's back forward to the beginning of this pandemic in 2020, Labrador Diagnostics actually launched a lawsuit to block coronavirus testing that used its patents. So this lawsuit actually has been denounced as the most tone-deaf IP suit in history. And I've already found that as of March 2021, no pharmaceutical companies actually had voluntarily joined the COVID-19 technology access pool created by WHO. Worse still, some of them have been condemned, have even condemned this so-called CTAP as a nonsense or even dangerous. So you can see that has been a serious problems caused by tech companies, and the technological benefits have been unevenly distributed. So how shall we deal with this serious problem? So the whole book actually deals with this single question: how can we develop and apply technology in the public interest? So in the book, I offer a rights and responsibilities approach to deal with this intersection. So I don't wish to define the nature and scope of the public interest, because this concept has been really problematic. Philosophers have been dealing with this concept for ages, and still there has been no consensus about the nature and scope of the public interest. So what I offer through this approach is to first of all, to protect the so-called the right to technology, and then to enforce a new concept called fundamental corporate responsibility. So the right to technology, first of all, should be protected as an human right under international treaty systems. And at the same time, it should also be protected as a collective right in domestic laws. And I also have a thought experiment to offer. I argue that this right could also be protected as a fundamental right under domestic constitutions. So this is the rights part. At the same time, I argue that we need to impose and enforce stronger corporate responsibilities upon tech companies. So first of all, we should require them to reciprocate for users' contributions. Secondly, tech companies should assume an active role responsibility, and they also should counter injustices caused by technological developments. So this rights and responsibility approach actually attempts to set in motion agendas for protecting the public interest through developing and applying technology. So this kind of rights in action and responsibility in actions approach, as I will demonstrate a little later, will help us further understand the nature and scope of the public interest when it comes to technology. So let me move on to the rights part. As I said, we should protect the human right to technology in the international system. So this human right actually is not new. It has been existing for nearly 70 years. First of all, the Universal Declaration of Human Rights actually has such a right. It states that everyone has the right to share in scientific advancement and its benefits. At the same time, the International Covenant on Economic, Social, and Cultural Rights also protects this right, but with a little bit different wording. It says that everyone should have the right to enjoy the benefits of scientific progress and its applications. This human right actually, as I discuss in my book, is actually one of the most profound lessons that framers of the Universal Declaration of Human Rights have learned from the Second World War. Framers, or we can call them international leaders, learned that technology must be utilized in the public interest. This is because in the Second World War, weaponry technologies were applied to kill an unprecedented number of human beings, and also caused an unprecedented level of damage to properties. So that was a catastrophe. And but the problem is that 70 years later, since the adoption of the UDHR, this human right actually has become a sleeping beauty, or an orphan, as I argued in my book, in the international human rights system. And you can see that no other human right has received such scant attention. And this human right has remained obscure, dormant, and ineffective. So I have asked many scholars and students whether they actually knew about this right. And very few of them actually told me they actually knew this human right. So that was a very surprising part of this human right. So, so what are the contributing factors? In the book, I discussed 3 contributing factors. First of all, this human right is actually quite obscure. It's in its nature and scope. And the ineffective human rights enforcement system, as we know, actually has also led to this kind of a problem. And thirdly, the international community's overemphasis on intellectual property protection has also caused this problem. I'm going to focus on the third factor, given the limited time. And the international community has been, as I mentioned, has been emphasized on IP protection. This is because IP protection system allows the distribution of technological benefits through voluntary transactions based on IP rights. So as you know, IP rights are exclusive rights, allowing rights holders to distribute technological benefits, such as a technical solution to an existing problem to the public. But at the same time, normally, this kind of voluntary transaction involve royalties. A party needs to seek permission from a IP rights holder, and then pay a certain fees, and then the rights holder will allow this party to use the IP asset concerned. So that's why the international community actually, for example, created the agreement on the international protection of IP rights, the so-called TRIPS agreement. And World Intellectual Property Organizations has created new copyright treaties, protect digital copyright. For example, the WIPO Copyright Treaty. In the past few decades, the international community actually focused on this kind of intellectual property protection schemes. And that's why this human right, to a large extent, has been ignored. So how can we resurrect this human right? So in the book, I argue that in order to resurrect this right, we should protect it as a collective right in the international, first of all, domestic law and domestic protection will give this human right a very good point to have it resurrect. Let me quickly talk about the concept of collective rights. I think it's pretty easy for the audience to understand the nature of individual rights, such as property and privacy, because these, every one of us has such individual right? So they protect our personal interest in property or privacy. So these rights are individually held and enjoyed by each of individuals. And at the same time, collective rights function for a different purpose. They protect people's interest in their social membership instead of this kind of their individual interests. So first of all, I think societal rights, demonstrate the importance of social membership and this kind of collective element of rights protection. For example, the right to development has been protected as a collective right. Members of a society or of a country can enjoy collective interest in, for example, in the natural resources that exist in a society or in a country. So they have the collective right to develop such natural resources. So these natural resources are not divided in individual parts to be enjoyed separately by individuals. Instead, they are held in as collective assets for all the members of a society or a country. At the same time, group rights have also been designed to protect certain groups' collective interest. For example, minority groups have enjoyed group rights to their cultural identities, their indigenous resources. So for collective rights, the question largely deals with we instead of me. The me question is for individual rights. So I argue that we should draw on the concept of collective rights to protect the distribution of technological benefits. And so first of all, we can protect societal rights to technology. They promote the collective interest in public freedom derived from enjoyment of technological progress. And so society members' fair share of technological benefits in sectors range from public communication, public health, to public transportation. And these technological benefits are crucial to the provision of the goods and institutions necessary for them to take part in civic life in public spaces. At the same time, I also argue that group rights to technology should be protected. Such rights protect the collective interest in group freedom by allowing group members to take advantage of technological benefits. They also guard against the uses of technology that are harmful to group interests. For example, facial recognition technology has, to a certain extent, be applied to discriminate against certain group of people, for example, based on their race. So certain facial technology recognition technology, they actually, for example, discriminatory exclude certain group of people. So they would automatically detect that, well, this particular group of people will be more vulnerable to certain kind of detection. And so this is actually harmful to the interest of group of people based on, for example, based on race. And then there are also other group of people, for example, on the basis of gender, on the basis of cultural identity. And thirdly, I also argue that we should protect the fundamental right to technology. And so this is, as I mentioned earlier, this is actually a thought experiment. So let me quickly talk about the concept of fundamental rights. In constitutional law, some liberties are actually so important in the sense that they should be deemed fundamental rights. For example, freedom of expression, property rights, they are normally deemed fundamental rights. For example, under the US Constitution, fundamental rights are protected as constitutional rights against any encroachment exerted by the government, unless the government can provide compelling reasons for doing so. And the government should also adopt the least restrictive measures in encroaching upon such fundamental rights. And some of the fundamental rights, such as freedom of expression, property, are expressly protected by US Constitution. But certain fundamental rights are protected as unenumerated constitutional rights or fundamental rights through the 14th Amendment to the US Constitution. The 14th Amendment states that no state shall deprive any person of life, liberty, or property without due process of law. So US judges have interpreted this concept liberty in the manner that it can accommodate fundamental rights that have not been enumerated under US Constitution law. So some unenumerated fundamental rights. So I want to draw on this concept, liberty, under the 14th Amendment to argue that we can also recognize technology as a fundamental right. And this new right actually entitles everyone to enjoy the benefits of fundamental technologies. So this new right would create a positive rights mandate for ensuring equal distribution of technological benefits. And so what are the fundamental technologies then? So such technology should be deemed as fundamental when it comes to the fundamental interest that citizens may have to the sustainability of their lives and freedoms. So examples include electricity, transportation, telephones, and the internet. So I can't imagine that our life can go without electricity. Public transportation is very important for everyday life. The internet, as I mentioned earlier, is crucially important in our daily life. This point has been clearly demonstrated by the current pandemic. The internet as our 21st century public square, it's really essential. So the internet access is pretty easy for us to understand that this kind of technology is fundamental to the sustainability of our lives and freedoms. But I have a caveat to offer here. We should not protect, for example, people's claim to have luxury cars as a fundamental right, or people's claim to have an iPhone as a fundamental right. That's a wrong point. The fundamental right is designed to protect people's access to, for example, public transportations. From this perspective, government should provide public transportation services, for example, buses. Okay, the government should not be required to provide luxury cars to people. Okay, so just this kind of fundamental technologies should be subject to this new right. So let me move on to deal with the second part of this book that deals with the so-called fundamental corporate responsibility. As I mentioned earlier, the first responsibility is about requiring tech companies to reciprocate for users' contributions. So reciprocity is key to this responsibility. Reciprocity as an ethical norm requires that one should respond to a positive action by another by returning that action proportionally. For example, if a friend gives you a certain favor, normally you should appreciate it in the first place and then return to his favor to a certain extent as you see fit. So this kind of reciprocity will actually promote friendship. I think friendship is the best example about reciprocity. So I think users' contributions actually require tech companies to reciprocate. First of all, users have contributed a lot of content to tech companies. Easy to understand that, right? Facebook, has hosted a lot of content posted by its users. YouTube has been hosting a lot of videos uploaded by users. So these tech companies actually, survive on the content contributed by users. And tech companies also rely on users to earn an advertising revenues. I think this is pretty easy to understand. Advertisements circulated through social media platforms actually target users, right? Without users, there will be no advertisements. And users also have contributed a lot of personal data and public data to tech companies in order to promote their innovation. So tech companies' innovation actually draws on such data. So that's the reason why tech companies should reciprocate for users' contributions. And secondly, tech companies should assume an active role responsibility. So role responsibility, again, is also an ethical norm that require people to assume certain responsibilities when they take upon certain roles, such as, for example, as a husband, as a sea captain, or a judge. For example, when a person serves as a judge, then he or she needs to make impartial judgments because of that role, right? Okay. So in the book, I identified 3 crucial roles that are played by tech companies. First of all, they play the role of information disseminators. As we know, most of the social media outlets have been disseminating a lot of information, daily news, entertainment information, etc., etc. They also collect information from their users. So this is a pretty obvious, right? Many of users may not be aware of this fact, but personal data is being collected by tech companies all the time. So that they play the role of information collectors. And they also create information through innovative activities. For example, AI technology actually creates a lot of new information for us to discover. For example, diseases that may have exist in human body, how to drive cars without the aid of human contribution. So these kind of the new information generated, let's say information about innovation is also crucial. So given that tech companies play these roles, they should play such role responsibilities properly. And thirdly, or we could say last but not least, tech companies should also confront injustice caused by technological developments. So social justice actually is a fundamental value in our society. It is intended to minimize the impact of unequal distribution of resources and status discrimination. So this requires, as a fundamental value, social justice requires people to assume certain responsibilities to redistribute resources or change status discrimination. Okay, so this is a responsibility-driven value. If we want to promote it, we need to impose responsibilities upon people. In the book, I demonstrate that technologies have actually caused injustices. We can call it technology-driven injustice. For example, access to technology benefits has become a really serious social justice problem. The access to the internet, as I mentioned earlier, has actually become a severe social problem. For example, half of the global population actually has not had adequate access to broadband internet. This is not, internet access is actually not a problem alone. There are many problems arising from the distribution of other kinds of technological benefits. And also use of technology can cause social problems. For example, improper use of technologies have caused harm to our society. Air pollution, water pollution have become really common problems. Global warming is alarming. Technology has been used in a way that will be harmful to the public interest. So that's why we need to require technological companies to confront such injustices and require them to take it seriously and take actions to deal with them. So I think I'm running out of time, and I look forward to your questions and comments.